Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about custody law. I'm joined once again by my co-host, Jesse Barrientes, and we have a special guest today, Corey Bandes. Welcome, gentlemen.
Good evening.
Welcome. We're going to talk about custody, which is a very popular topic. Divorce is so prevalent. Most divorce cases, or a lot of them, involve children. And we're going to talk about several of the types of questions that we get asked almost on a daily basis. Starting with you, Jesse, let's jump right in.
Sure.
What is sole custody?
Sole custody is when one of the parents, the residential parent, gets to call essentially all of the shots. They get to make the determination and the decisions about what school the child's going to go to, about what religion the child is going to be raised in, about doctor's appointments, and just all of the decisions, all the day-to-day decisions that a husband and wife would normally make together. But just with sole custody, that one person is going to make all of those decisions, on his or her own.
A lot of people think that if they don't have custody of any sort, they don't get to visit and they don't get to take a part in their child's life. Is that correct, or is that kind of a misnomer?
No, that's not true. Even if somebody else has sole custody, the other party most likely will get visitation rights. And a very standard visitation is generally every other weekend, alternate holidays, and special holidays and birthdays, Father's Day, Mother's Day, that kind of thing. And so just because it's labeled sole custody doesn't mean that that they're not going to have any interaction or be in the life of their child.
Okay. Corey, let's turn this over to you. There's a big push recently for joint custody, where men particularly are being sold on this father's rights, and they want to have a say in the lives of their children. What is joint custody? Definition, basically.
What joint custody is, or another way to put it is, it's joint decision-making powers. Typically, the children will live with one parent, not the other, but both parents will join in decision-making, particularly what I call the big three areas of non-emergency medical care, religion, and education. Coupled with that is that the children typically live with one parent, not the other. The other does get frequent and a specific visitation schedule. And that's basically what joint custody is.
Okay. Let's talk about joint physical custody, whereby both parties want to share the day-to-day operations of the children. They want to shuffle them back and forth from house to house. Do the courts go along with this notion, Jesse?
Well, it really depends upon the particular situation, because what the court is interested in is what is the best interest of the child or children. And there may be some circumstances where that may be a good idea, and it may be in their best interest to do that. The problem, though, sometimes when you shuffle the kids around is just what you said. You're shuffling them around. You're interrupting their schedule. Most of these things typically tend to work when, the parties are together in proximity, when they don't live very far from each other, when the parties can agree. That's one of the major things, because if the parties can't agree on simple things, then they're going to have a difficulty in terms of making those decisions together.
It's often a selfish gesture on the part of the parents, is it not? That they don't want to relinquish the day-to-day, and they want to have at least 3 or 4 days per week.
Yeah, it is very often, and it's a shame. Again, each situation is particular, in terms of what's going on in that situation. However, again, the major concern in all of this should be for the children. Not that I want to get back at my spouse or my ex because they did this or that, or hey, guess what, I don't want you to have an extra day. But hey, I want my child to have the benefit and to enjoy all that he or she can have in whatever we do.
What are some of the factors, Corey, that the court will consider in determining custody?
Well, there are several factors. One of them is the psychological bonding that exists between the particular parent and the particular child, the ability to raise the children, the ability to know the day-to-day events of the child, what should be happening, the schooling, the extracurricular activities. Also, there may be a matter of health concerns, both as to the child's health concerns and the parent's own ability if they happen to have any medical problems. Also, I would say living conditions. If one parent is substantially in a living condition which is better than the other, that may warrant custody for one, not the other. If there's separate bedrooms as opposed to having to crowd people into fewer bedrooms, that kind of thing.
Jesse, what are some of the court procedures, just topically, that are involved in a custody battle?
Oh, there are many, but just to put it down, essentially, you would be coming in, if it's just a fresh divorce, that would be one of the issues that would need to be determined. Or if it's what they call post-decree, which is after there's been a judgment of divorce entered, and now somebody wants to change custody. It starts really in either case by filing of a petition, generally for temporary custody. What I usually do is file a petition for temporary and permanent custody, because it's the same factors that the courts look at for either one. They're very hesitant, if not reluctant, to do temporary custody. They're just going to do the whole workup. And what will happen very often is sometimes a guardian ad litem or child representative would be appointed for the child. And we can get into all of the minor differences, but beyond that purpose.
Very important, though. Does the issue have to be mediated when there's a custody dispute?
There is a mandatory mediation in several counties. And that's great, because what that does is it gets the parties talking, which is what they should be doing. Because a custody battle is very, very involved, time-consuming, and very expensive. And it's difficult not only on the parties, or hard for the parties, but also on the kids, too.
It also educates the parties as to what is custody and what are the different ramifications of having custody and not having custody, correct?
That's true. And there are a lot of counties that require a parenting class, either way, whether or not there's a custody battle or not.
Yeah. Well, we're talking about custody. We're talking about the children. One thing that often gets overlooked a lot, and Corey, you can speak to this, how are the children adversely affected throughout a custody battle?
Well, certainly the court system wants to shield the children from the system. They don't want the children to actively come to court. They want them to be represented by a child's representative or guardian ad litem who will speak for them. Yeah. There may be situations where there may be what's called an in-camera interview where the judge speaks to them. But generally, they don't want children there. They want the process to be done without them involved to a great extent, and so that the adverse effects on them are minimized.
The children are often hearing things from their mother or father derogatory about the other party. Is that correct?
Well, unfortunately, that's very true, yes.
And the court frowns upon this tremendously, correct?
Yes.
Okay. Jesse, let's talk about cost. Everybody cares about money. What are we looking at here?
It's everything is based upon time and based upon, and generally, you pay your attorney on an hourly basis, and that can range anywhere from $175 to $300 to $600 an hour, depending upon the level of skill and expertise that an individual has. But you can probably expect to pay, and again, this is just a general statement, anywhere from $5 to $30 to $40 or $50,000 is conceivable. Now, when we're talking about custody, in addition to having a guardian ad litem, which both of the parents are going to have to pay, it's another attorney for the child, and both parties are going to have to kick in based upon their relative position in terms of 60-40 or whatever that amount is to pay for that person. There's also what they call a 604B evaluation, which is an independent evaluator. The children and the parties are sent to a psychologist. Now, depending upon who that person is, that cost can be $3,000, $6,000. It can go up. And what happens is they go through all of the factors that the court looks at in terms of determining custody, and then they render an opinion. And it's really, I would even dare to say, and help me out here, Corey, is I think that that would be the court's right hand, just like the child's representative would be as well.
Absolutely.
If one party doesn't like the results of what that evaluator says, then they can hire their own. They can come in for...
They can ask for another independent evaluation.
Exactly.
Besides the one that's already been done.
That's right. And of course, again, that is going to cost more money. So
yes.
It really depends. Now, in parties, a lot of people don't have the money. So what happens sometimes is they try to get somebody, maybe a child rep to do it, or guardian ad litem to do it, pro se, or pro bono, without charge.
Okay. You've mentioned child rep, guardian ad litem, psychologist. You've thrown out a lot of different players. Corey, can you itemize the typical players that are involved in this dispute who are offering opinions to the court?
Well, absolutely. First, what you have is you have an attorney for the father, an attorney for the mother. You'll get occasionally an attorney representing the child, and that is what is called a child's representative. A child's representative is there for the best interests of the child. In addition to that, there is, as Jesse mentioned, the 604B, which is it's legal code for
604B. Explain that, please.
It's a psychological evaluation of all parties, the father, the mother, and all children. Generally, the children have to be 2 years old, 3 years old, or older. If they're too young, then a psychological evaluation really doesn't held.
But importantly, the number 604B is referring to the Illinois Marriage and Dissolution of Marriage Act, correct?
Exactly.
Okay, because people throw that out. We're doing a 604, we're doing a 604B.
750 Illinois compiled statute.
Non-attorneys don't understand what that
When
means.
it comes to talking to my clients, I never mention those code numbers because it doesn't mean anything to them. If I say psychological evaluation, they know exactly what I'm talking about. Now, in addition to that, there's one other thing, which is, at least in Cook County, I'm not sure if they have this in 2 pages, a home study. There's something called Department of Supportive Services, which is a free service of Cook County, which will go into each respective home of the father and mother and see what the living arrangements, the kind of the living arrangements I was talking about in my last question, are, and see what's more suitable for a permanent custodial relationship.
If the parties cannot agree on custody, the court will be forced to make a decision. Is that correct?
That's correct. And here's the thing for people to understand. When you have the opportunity to make a decision, you have some power because you have your destiny in your hands. Once you give that up, once you put the evidence before the judge to make that decision, he's going to make a decision based upon the evidence. And I promise you, although we have just a lot of great judges out there, but there's no way that they could possibly know the intricacies of every situation because they have hundreds and thousands of cases that they go through on a yearly basis, and there's just no way. And so that judge is going to make a determination based upon the evidence and based upon the evaluator who has spent, maybe 10 hours, if even, with the child and with the parties, and after he makes a decision, it's going to be too bad for you because it's going to be what the court says it is. I mean, you have other rights in terms of a motion to reconsider or even to appeal it. But for the most part, once that's done, it's what the judge says, and there's going to be one party. Generally, both parties aren't happy because neither party gets all what they want. But generally, one party is going to be happier than the other.
Right. Of course. Let's talk about negotiated settlements. Corey, I've seen instances where the document will literally read sole custody, but some of the language and some of the terms that is couched in the agreement comes awfully close to a joint custody arrangement.
Well, that's very true.
Is this to appease the non-custodial party?
Well, quite obviously, yes. It's an attempt to have involvement in the children's lives of the parent that isn't the sole custodial parent. And many times what the documents such as those will say is that there will be joint discussions between the parties, but that ultimately the one parent, not the other, will have the ultimate decision-making if the parties can't agree on what to do in a particular issue. So it's not joint, but it's a step below joint, if you will.
Okay.
Joint custody.
Let's say custody has been decided. Can that decision be overturned, Jesse?
Well, it depends what you mean overturn. If you appeal it, I mean, certainly depending upon, I think the standard review is against the manifest way of the evidence. But can you come back in and try to modify the custody? Absolutely.
Yes. Say the non-custodial parent doesn't feel that the custodial parent is properly taking care of the child or children. What will that person do?
Well, then you can come in, and there's really a couple of time periods here. The first thing is if it's within 2 years from the time that the judgment for custody was entered, then you have to show endangerment, which is, and I believe it's by clear and convincing evidence, and it's a very hard standard to prove, a very hard burden. There has to be something different, obviously, than what happened at the time that it was entered. If it's after 2 years, then it's just the best interest of the child standard, and they look at all kinds of factors. Some of the factors they look at when they're looking at just the best interest of the child is first the wishes of the parents, and we all know pretty much, okay, the former husband's going to want him with him, the wife is going to want him with her. They look at the wishes of the child, but the difference there is depends upon the age. As the child gets older, the wishes of the child has more weight, has more credibility with the court. They look at things, for example, in terms of has there been any violence within the relationship or the propensity for any individual to have violent tendencies? Have there been any order of protections, any domestic batteries, those kinds of things? They're looking at the ability of the parties to be able to interact with each other, to encourage establishing a continuing relationship with the other child, or between the child and the parent, to do those things. They look at also a host of other factors too, not just the statutory factors. There are other factors that the court look at. It's really kind of the bigger picture.
Okay. Oftentimes a custodial parent wishes to relocate out of the state with the minor child. If the judgment for dissolution is silent as to that issue, Corey, what does someone have to do to actually get permission to remove a child out of the state?
They have to do a motion in court requesting the right to move out of the state, and there are several factors that they have to show to the court where it's to the child's betterment and their own betterment, of course, to go out of the state. In addition, there's a factor in which they have to show that there's going to remain a relationship between the parent who's going to stay in state and the child, and the ability to make sure there's frequent visitation, and that the parent who's going to be the one remaining in the state isn't exempted from the child's life, basically.
Aren't you really destroying, though, the ongoing relationship that non-custodial parent has with the child while they're in the same state together?
Invariably you are, but the court wants to make sure that there's, again, some frequency of visitation, telephone calls, things that will keep the relationship going between the parent who's staying back in the state of origin, Illinois, we're presuming, and the child moving to whatever state it happens to be.
Generally, what happens in some of those situations is that the non-custodial parent, the person who doesn't have physical possession, gets longer periods of visitation, perhaps more of the summer or even the whole summer, the Christmas break or spring breaks, and so they spend more time with them. Now, generally, people are working, and so during the week, where are the children going to be? They're going to be in school or daycare or something like that. Now, during the times of vacation, it allows that other parent to be able to spend more time and even possibly to even create more of a bonding situation because you have the ability to spend that time on a continuous basis together.
Does the court often allow one parent to have custody of one child and the other parent to have custody of another child? Let's say there's a brother and a sister. Has that split happened? Corey?
Has it happened? Yes, it happens very infrequently. The courts definitely discourage split custody, and I mean they would need psychological evidence from a psychologist, proof positive that it's to the betterment of the children. Typically, they want the children staying together in one household.
Has that been your experience as well?
That has. Actually, I have a case right now, and of course we can't mention any names, but the situation is, it's a pre-decree, and custody is an issue. However, one of the older children is staying with one parent, and the two younger ones are staying with the other parent. And that's kind of the way it's been. And so the way I see that going is most likely what's going to happen after a custody hearing, after all these things we talked about, is that probably the older child will continue to live with that the parent that he's living with now, and the child. And the difference is that's something that has been established. And so, and when you talk about the best interest of the child in this particular situation, what you're absolutely right. It's few and far between to do that, to split them up.
Are there a lot of attorneys out there that are possibly misleading fathers into believing that they can win custody when the mother is a good mother and there's nothing wrong with the way she's parenting? Is there some of that that's developing in the community, honestly?
Is that a question for Corey?
It's a question for each of you because I receive a lot of calls from men who want custody, and you have to be careful on how you make...
I would say this. You have to tiptoe through that question for the following reason. Certainly, the parent who is bonded with the child more effectively will be the custodial parent 9 times out of 10. The simple truth is, mothers do tend, and even in this day and age, to still be the parent who's the more nurturing parent. The father doesn't typically win sole custody. That's what you're asking about, is sole custody.
Yes, sole custody.
Fathers do not typically win sole custody, even in this day and age, because, number one, there are time constraints. Typically, the man is working a job that is of greater hours than a woman, more times than not. And the mother simply has the better ability, most of the times, to care for the child. So, I will say, it is somewhat misleading for most men. That's what it is.
What could a father who wants to be involved in the child's life hope for? What's the best he can hope for?
Well, and I'll tell you that, but before we get to there, I just want to make just one quick comment about, I don't know if there are attorneys misleading people out there. There may be, there may not be, okay? But the important thing is to look at is everything that you said, Corey, and that's true. Is it worth to be able to review a situation Absolutely. There's no harm in that. In fact, many agreements, especially the joint parent agreements, require, and they have it stated right in there, that it's reviewable from time to time because of what you're trying to do. But what's the best the father can hope to do? I mean, it really depends on each individual situation. You know, what I would do is, if I was in that situation, okay, everything, all of my energy, all of my time would be, you know, just to make things better for my kids. You know, I mean, to try to get along. That doesn't mean that you lay down and you let the other person have their way with everything else. But you know what? Hey, I want my kids to go to Disneyland, and she's taking them to Disneyland when I should have them during the summer. So guess what? I'm going to reschedule my life and make things different for me so that my kids can enjoy those kinds of things, to be able to have that experience. And that's, you know, if you had that on both sides, wow, what a great thing that would be for the kids. But, you know, what can the father hope to do? The father can just hope to just spend his time to try to nurture and develop the relationship with his kids. I would hope, as a father, that you would know the birth dates of your kids. I mean, that's something that we use as attorneys in litigation. Okay, you don't know the birthday, you don't know the significant dates, you don't know, you know, what little Johnny or little Timmy is doing in Little League or the stats or anything else, or that he's in karate or hockey. Those are things that you should know. And if you don't, make it your business to know those things. Your kid should be your life.
Maybe that's being kept from him. Maybe he's not being advised of how the child is doing in school and what extracurricular activities the child is participating in.
And if he's not, then that's where a trip to your lawyer can help, because, you know, depending upon what the agreement says, there are petitions and motions that can be filed, because there's no doubt in my mind that generally, and again, just generally speaking, any judge would most likely grant those requests, because those are standard. Even to know, to have access to the child's school records and to have access to the parent-teacher conferences and all those things. And I think, even though somebody may have sole custody, I don't think that a judge would prohibit a father from having access to those kinds of things.
Right, by statute.
Right.
The non-custodial parent, assuming no exigent circumstances involving violence or whatever, the non-custodial parent has full access to school records, medical records, dental records, psychological records by statute, under the law.
Right. We just hear so many stories all the time where the father is not being kept advised on anything and is not able to communicate with the child in certain circumstances. And I think those are the cases where that person has to get themselves before a judge with a petition and start getting the rights that they deserve. Would you agree?
Yeah, absolutely.
What is your opinion in DuPage on how custody cases are handled? Do they move swiftly through the system, or do they take an extremely long period of time in DuPage?
They're supposed to take priority, and cases that have the special, you know, the exigent need, those will be dealt with, you know, and given the attention that they need. But it's a process. It takes a long time. You know, once you have worked out where the kids are actually staying at, and generally, and you're right, Corey, most of the time it's with mom.
Yes.
And if there's a petition on file, the judges will go through, and they're pretty good about moving along. There are some judges in DuPage that move things along a little bit quicker than others, and you know who you are. and that's good, because it forces people, you know, when you have a deadline to make you do that and to do those things. But for the most part, you know, things get done in a timely fashion.
But the law does say that custody cases, and most likely custody cases involving people getting divorced, are supposed to take priority over non-custody cases.
There's a new law that came down the pike not too long ago from the Illinois State Legislature, which talked about mandatory parenting class in cases involving custody. Now, I know in DuPage they've had that for a long period of time. This is relatively new to Cook. Is that correct?
Well, it is relatively new to Cook, though there's something called Focus on Children in Cook, which is now required for all people going through a custody situation. And there is the mandatory mediation, which prior to this had always been discretionary depending on whether there was need. Now they're making everyone go through mediation and everyone go through Focus on Children.
Have you found the parenting class to be helpful to your clients, or is this something that's more of a hoop that they have to jump through to satisfy the court?
It depends on the people. For some people it's very productive, and it turns out that they come up with full agreements as to custodial and visitation arrangements. For other people, unfortunately, it is a waste of time, but there's no way of knowing that until they go through the process first and find out whether, in fact, it worked or not.
Right. I hear comments like, why do I need to go to a parenting class? I know how to parent. I don't need a class to tell me how to parent. In DuPage, they've had it even in agreed-upon cases.
Yeah.
Whenever there's a minor child, the parties both must attend the parenting class. Is that correct? And is this helpful?
It is, and I think it is. I think anything, any bit of knowledge that you can get that's going to help you, help your children get along through this situation is a good thing. It might not be good for you. You might think that you know better, but you know what? Sometimes when you sit down and you really look, and if you pay attention and you listen, you might actually learn something. Because nobody knows. You don't have the instruction manual. Nobody gave it to us, and you learn it. It's for people out there who have kids. It's an experimental basis. You do the best you can based upon how you were brought up and upon what you know and upon what you apply in your life. But any little bit of knowledge that can help you do that is, if you listen and apply it.
Right. You don't feel it's just a little bit more government intrusion into your life?
Well, I think that certainly you can look at it that way. I mean, and there's a fee for that. That's true enough.
What is the fee in DuPage?
I think that's $75, if I'm not mistaken.
Are you familiar with
in Cook County, mediation is free. Focus on Children is $25 per person.
Dave, do you know?
Will County is $80 a person. Will County, $80 a person. Now, that's a hardship for a lot of clients who have to take that class.
Yeah. I've never had a situation to try to waive that expense, but I'm sure that in the appropriate circumstances, it's something that probably should be granted.
There's something called a 298 petition, which is someone under the poverty line. If they happen to be under the poverty line, the cost of Focus on Children will be waived.
Yeah, I think you'll find that some counties are more liberal in granting that 298 petition than others. Once again, they're very difficult to get approved in Will County, and they're much more liberal in Cook County in granting that 298 approval. Final thoughts on custody, Jesse?
If you can agree and try to resolve your dispute, then you have the power over what's going to happen. You have the power over your destiny. If you let the judge decide based upon people who have seen you and your children for hours, let alone the years that you've been with them, then you're taking a chance. It's something you really need to sit down and discuss and to try to work out if you can.
And Corey, you always encourage a settlement as well.
Absolutely, yeah. You want to shield children from litigation. You don't want to place them right in the middle of a pit. That's what I was saying.
It seems like the parties have come so far. They're married, they have children, they've gone through so much. You would think that reasonable minds would gather in a room and be able to work out an arrangement. And that's what typically happens anyway, is that correct?
That's what's supposed to happen, but a lot of times most of this is motivated by contempt or hatred or just wanting to hurt the other party, and what happens in the course are the children get injured and hurt. There's always three sides to a story. There's what he says, there's what she says, and there's what actually really happened. Unfortunately, nobody's really going to know what actually happened, and the best, and that's what the judges do. They try to meet that someplace in between.
Okay. Well, I think we've covered quite a bit on custody. What I'm hearing from both of you is try and work out an agreement, try and be reasonable, and resolve it yourself. Don't put it in the court's hands because it's very difficult. It's long-standing, it's painful, it's expensive, and it's basically a nightmare. And if you can avoid it at all costs, correct?
That's true.
Correct.
Okay.
Absolutely.
Thanks for joining us on Legal Action. We've talked about custody today. We'll see you next time. Thank you.